Welcome back to the Pitch to Product podcast. Today I'm here with a special guest, Craige Thompson of Thompson Patent Law. We're going to talk about the importance of IP in the overall strategy of bringing your product to market and generating the value that you're bringing it to market for. We'll hop right into it. Craige, if you could introduce yourself.
Hey, Jack, I'm really excited to be here. Thank you so much for bringing me on. And, especially with 52 launch, I just want to start off by giving you guys props because, the father of modern management, Peter Drucker, said the only two functions of business that create customers and keep customers is innovation and marketing. And that's right in your lane. So I just, the innovation, that's your clients that are trying to innovate and marketing, and you help them with that. And that's such a need for that. So I'm just really, I think it's really cool that you found that at 52 launch.
Well, we appreciate you saying that.
My background's as an electrical engineer for 10 years before I went to law school, doing product development, product realization, designing products myself. So I'm really, we have some synergy there as well. But I was doing electrical design or electronics. And then I went to law school and, went to, of course, into patents and been doing that for the last 26 years. So I started off at the number one patent firm in the world, Fish and Richardson, for 7 years, learning
Oh, yeah.
litigation and patent prosecution and licensing for the Fortune 500. And now, since 2009, I've been doing for a lot of the smaller companies, a few big ones. And, we've had thousands of clients get, several thousands of patents all over the world. So.
Yeah, as part of my role here at 52 Launch, I look for patent attorneys and IP firms that we can connect our clients with. And of the dozens of firms that I've looked at, researched, talked to, Thompson Patent Law systems are pretty unique, very impressive. Clearly, a lot of thought behind them, a lot of experience in building them. And we'll get into some of those in a little bit. We appreciate that feedback. And it's great to have somebody on the podcast with the amount of experience that you have. Awesome. So jumping right into one of those really unique processes that you guys have set up. I understand that the way you guys do prior art searches is pretty unique and more of an involved experience with your clients. So I wonder if you could tell me a little bit about that.
Well, I think prior art search is it's been a controversial topic throughout my career. Some people say you shouldn't do it. Some people say you should. I eventually landed on you should always do it. In my opinion, especially for entrepreneurs who have limited capital, they want to be smart and efficient with their cash and what they invest in. And it comes down to, at the end of the day, you want to know if you're going to invest in a patent or not. I actually wrote a book about it. It was a number one bestseller on Amazon and in the business and legal, called Patent Offense, if you want to know more. We do have a free gift, so I'm not selling the book. We give your audience here all those resources for free at the end if you'd like.
That is
On
awesome.
our website. But the point is that there's really a big decision whether you should get a patent or shouldn't get a patent. And I have a 7-step process that I lay out in the book, or in the resources that we'll give you for free. And the first 3 steps of that 7-step process are all about figuring out whether you have something patentable or not, so you can make an informed decision before you spend all this money and time and effort. And then there's a very high chance, if you don't follow this process, that your results, either in your likelihood of getting a patent or getting a patent that matters, which most patents don't generate a lot of revenue if they don't follow the proper process. So our lightning prior art search that we came up with is an innovative way of getting that process started.
Very cool. And I would encourage people who are thinking about a patent to head over to thompsonpatentlaw.com and look into that more. They've got a whole bunch of resources on their website, some really interesting blog posts. I learn something every time I go take a look at your site. So it's a great resource.
Well, the
And
unique
to
thing about oh, sorry, go ahead.
oh no, absolutely, you go ahead.
Well, the thing that's really unique about that prior art search, just real quickly, is the three I's. It's iterative, it's immediate, and it's interactive, which is really different than a typical prior art search where you would sort of send it off and then they might send it off to India to do it, or somebody
Right.
might do it at a junior level, and then you know you get some sort of report that's like, here's a bunch of prior art. If they print it out on PDFs, it'd be a stack this thick, and they'd say, "Here you go,
Yeah.
here's your report." And you're like, "Okay, so what's the answer?" The question is, should I get a patent or not? And that doesn't really
Yep.
answer the question. And so with the immediate, we actually do it live with you. You get immediate feedback, and then we can adjust with you in real time in a 1 hour meeting, which is super cool because it helps you sharpen your thinking. It helps. We're working together. We're co-creating this search report. It's interactive, meaning you're involved in the process. It's not, somebody in a room doing a search where you kind of don't know what's happening. You're there. You're like, oh, hey, I forgot to mention this, and then like, oh, if you didn't mention that, the search wouldn't have
Exactly.
been as good.
Right.
And it's iterative, meaning the first time we were like, oh, there's a problem, but we can shift, we can pivot, and we found great results from that, whether helping people either determine whether they should get a patent or not.
Yeah. Yeah. From the product development side, I imagine that would be a, a pretty significant learning experience for most inventors just to
Mhm.
see all the other ways that people have tried to do what they're trying to do, what exists on the market, who they're actually competing against. I'm sure you've had clients find sort of product improvement angles by
Absolutely.
doing those searches with you live. So it's a really cool system that you guys have set up.
It's surprising. Sometimes we're able to, the inventor sees, oh, somebody was doing that. I didn't. Well, let me say that the second most common thing everyone says to me is, I've searched everywhere and there's nothing else out there like this. That's the second most common thing. The first most common thing is, how much is it, of course. But
Yep.
so everyone says almost those exact words is, I've searched everywhere and there's nothing else out there like this. And of course we find 99.9% of the time things that they're surprised by. Oh, I didn't realize that was out there. And that's closer, and it could be a problem. But the nice thing is you're there with a skilled patent attorney, not some searcher, not somebody, where you're just getting a report. You're there where they can help you. Like, well, the real thing is obviousness that we have to overcome, and it help you pivot and dynamically adjust and see to get. And sometimes we're able to, like you said, find, hey, maybe there's an improvement here, and then sparks in that next level that actually gets them to skip a generation or two of technology
Right.
and improve their idea to something even better than what they sort of came in with. So it can sharpen.
Yeah, absolutely. And so to get a little bit back towards something you were talking about a minute ago is the value generated by a patent. I noticed something on your website, some sort of calculator that people can use to sort of evaluate or predict the future value of a patent
Mhm.
even before they've started selling the thing that they're thinking about patenting. So
Mhm.
I'd be interested to hear how you think about that, what goes into that calculation, when you're so early on in the process.
Three numbers, and it's I'm. This is something that 52 Launch actually provides your clients, I think, with some great insights to help them get the three numbers. The three numbers are, what's your average retail sales price? What's the quantity you're going to sell per year? You know, and how many units, and what's the cost of goods sold? And experienced entrepreneurs who have been in a particular business for a long time, they sometimes they just know that they can
Yeah.
pick that out real fast. But a lot of people who are, you know, just inventing or innovating and they're early on in the process and they don't know how to come up with a cost of goods sold, or they don't know how to, you know, they 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 really they can't even come up with an estimate of a number from a marketing perspective of how many, you know, what do you think how many units you're going to sell per year. And but if you can come up with those three numbers, at least a good guess, and I think you guys 52 launches process, the way you take them through, you're going to get them there, I believe. So they're going to
Oh
have
yeah.
realistic numbers to project. Now the calculator, I put it on there. It's to make it easy. You can do this on the back of a napkin. You can do it on a whiteboard. You can do it in Excel. It's not rocket science, but you do the simple math and you can pencil out over 4 years is sort of my benchmark that I've used from a litigation and from a business standpoint. I think if you over 4 years, if your gross profit that you think you can accumulate total is over $2 million, then a patent, it should be something you should consider. It doesn't mean you can get a patent, but it
Right.
means it makes business sense if to protect it, because a patent is protection for your idea. If you can get good protection, it needs to be good protection, not just any protection. It needs to be quality, litigation quality. But if it's above that threshold, now you've got sort of an objective criteria. If because that's what it's going to cost to, you know, to enforce your patent. And if you can't enforce your patent, you know, you're not going to sue somebody for $50,000,
Right.
and you know, the lawyer's fees are going to be too much. Now that does not apply to Amazon products, by the way, but Amazon has a different threshold. If your main channel is going to be an Amazon type thing, but if you have to sue in district court, you need to be thinking at least $2 million over a 4-year gross profit.
Interesting. So talk me through why it's different with Amazon.
Amazon has a special program called Apex, and it's matter of fact, I did an AI search. This is talking about AI. Everybody talking about AI these days. I asked Grok about the Amazon Apex program, just, you know, thinking about what we might talk about today, just last night. And I've got the business version, the upgrade, the smart version,
Oh
and
yeah.
it gave me a totally hallucinated answer. It was totally wrong. And I knew it was wrong. And I said, that's the wrong answer. It should be X and Y and Z. And it said, oh, I'm sorry, you're right. So there you go for AI. AI is still, there's still judgment from an experienced. AI isn't the be all end all that everybody wants it, hopes it to be yet. But the Amazon Apex program and how it affects the ROI calculator that's on our website, it's on our homepage, or it'll be on our resources page, and it'll be in the free gift that we're going to provide for your audience.
Awesome.
Um, is the is the Apex is a very, very low cost, as opposed to district court litigation, which can be millions of dollars to go to trial. Um, it's about $5,000 of fees that you put in, plus about $5,000 for the attorneys to write a brief. And, you know, whether you say somebody's infringing your patent on Amazon and you
Hmm.
want to get them off, you can, you know, prepare this paperwork, send it in. The people who are selling the product, if they respond, they'll pay $5,000 or approximately, and you know, send it in and say why they don't infringe. And then it's some third party patent attorney, neutral arbitrator, says whether it infringes or doesn't infringe. And then if you're right, you get your money back, and they get kicked off, you know, or, you know, you defend and you keep them. Whoever wins gets their money back. So
Wow.
because it's such a low cost program, it's not millions of dollars of legal fees and trial costs and everything. You know, it becomes much more affordable if that's your main channel. There's a few other,
Yeah.
you know, eBay might have something similar, but the Amazon's probably the big kahuna.
That's interesting. I assume if I thought about it for a second, I would figure this out. But why does Amazon have such a vested interest in making this process easy for its sellers? Is there a
Well, I mean, obviously, if they're the storefront, they don't want to get sued by everybody for patent infringement all day
Okay.
long. There'd be an endless line of people suing them for patent infringement that they'd have to
Right.
fend off. So this is how they sort of relieve themselves of, wash their hands of it, and say, okay, this is our process, and otherwise, go away.
It's good. It's good. It makes a whole lot of sense. So you touched on AI. It's AI has certainly changed the way that we do things internally to an extent, but it's also changed the way that people come to us, what they're coming to us with in terms of like AI generated drawings,
Mhm.
um, AI generated market research. It'd be interesting to hear how you guys are using AI internally, how you're seeing clients use it. What is it good for? What is it bad for? Why can't it do your job yet?
Mm. Yeah. So, of course, we're using it in our search, so you can search a billion documents. You mentioned our lightning prior art search. Search a billion documents in 5-10 seconds, and then we can look at the
It's
top, and then
crazy.
we can iterate. That allows us to iterate really fast. So we've been doing that for years before a lot of people were talking about AI. So that's one angle we're using it. We're very careful not to use it for drafting too much, or sometimes it gives you a quick answer, just like Mr. Professor, kind of like Google. It helps us take time out of the equation, but we're not drafting agreements or license agreements, or we use more rigorous tools for that, like Lexis and Westlaw, and
Right.
but as far as, and also there's the judgment part. AI, and the problem with the, the 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 problem with prior art searching and knowing what you can get a patent on, and how to draft the patent application, because there are many audiences for a patent application. I don't, and there's the examiner, there's the inventor, there's the opposing counsel, there's the judge, there's the jury, there's the appeal board, there's all these potential audiences that you're writing for, and you have to have a judgment about that. And in the first instance, the second, well, the first one's the inventor, the client, but the second audience is the patent examiner. And we actually employ a former patent examiner, and I've had tens of thousands of negotiations with patent examiners, and that is something that you have to have the judgment to know how to craft, using the tools of words, a claim that is going to persuade an examiner to feel safe to put his stamp of or her stamp of approval, and allow a claim that is actually meaningful in a commercial sense. And it needs to protect the commercially valuable. And so it needs to be broad enough to actually matter, so that someone can infringe it. Otherwise, if no one can infringe it, it doesn't matter, and you're wasting your money. So we don't bother with those. We want to push the envelope, get as big of a claim protection as possible. That's your protection. And getting right to that line, and knowing the prior art and how to negotiate, and doing that before we even start writing the patent application, we're
Right.
thinking that the end in mind. Doing all that is why that comes naturally, like breathing, to me and to my team. But it's not something that people who think that they're just doing a search and there's nothing else out there like that, they don't understand how to win the game of patents. And so that's a little bit about why AI doesn't have the judgment. And I've mentioned it still hallucinates on simple things, and
Oh
it's
yeah.
not enough. It's not there yet, or I'm not sure when. And the interesting thing is about AI is that it's trained on, what is trained on is in the past. And uniquely, what we do when you patent things, we're doing things that haven't existed before. And so the most important part, it's not been trained on.
Exactly. Exactly. Yeah, I think people have this misconception, especially a lot of the clients that 52 Launch works with who are often launching their first product or their first business. There's this idea that
Mhm.
the process of writing a patent is very formulaic. It's it's very structured. It's sort of maybe even boring. And it sounds, when you frame it like that, it
Mhm.
sounds like, oh, AI could do this, no problem. The reality is, from my
Mhm.
understanding, is that every sentence, certainly with the claims in a patent, like
Mhm.
poetry might be a strong word, but it is every word in those sentences is there for a very specific purpose. And it's, the more I understand about it, the easier it is to see that AI is a long way away from being able to draft a patent that's going to hold weight.
Yeah. If you understand how AI really works and how it's trained, it's a statistical, process. It comes up with a different answer every time. It's it
Mm,
it if it's not and the words and the claims are super important, but the words that have all the figures and the specification to support those words in the correct way so that you don't shoot yourself in the foot. There's a lot of things that you can say. I've there's so the patent law is extremely complex. It's not simple. It may looks easy. It is not easy. There is a lot of subtlety to it that the that the layperson just can't even. They don't know what they don't know, and
right.
AI doesn't know it either. So they don't know what questions
Yeah.
to ask, and I don't know if the AI isn't going to give you the best answer always. So
Yeah. On
yeah,
our
you
end,
can
we
write an
found,
application. You can write the format, but that doesn't mean it's going to turn into a patent that's going to protect a commercially valuable joke point.
right, right. That's a different challenge entirely. We've certainly found some interesting ways to use AI internally at 52 Launch. On the branding and marketing sides, we'd be fools to not be using AI just for the efficiency gains alone.
Sure.
One of the things that truly AI can't even begin to touch is the product design side of things. And I think there's another misconception here where
Mhm.
you can come up with a product idea and get AI to generate a picture of exactly what you had in your head. And people tend to think that is worth something. I don't want to say it's not because it's really good to communicate your vision to somebody else,
Mhm.
like our design team. But the difference between an AI created rendering and a 3D CAD model that is optimized from day one for a specific manufacturer, like there's a lot of steps in between those two things. And AI is just so far away from being able to do computer aided drawing and design, and certainly in a way that it's creating products that are manufacturable at a price where you can be competitive in the market, which is certainly one of our primary focuses here at 52 Launches. Doesn't matter how good the product is if it's priced out of the market.
Right. I mean, I remember my days when I was at Plexus as a design engineer, and we'd sit in the design center and engineer stuff, on schematics, and then we'd go in the lab and prototype it and everything. And then we'd go across the street to the contract that to a Plexus is a contract manufacturer. They the long lines of soldering, wave soldering, and surface mount soldering,
Cool.
and all this, cranking out lines and lines of circuit boards and, you know, that's a different world. I mean, design for manufacturability, you can design something as thinking you're really smart as an engineer, and then you can't manufacture that, So that's where I really appreciated that you guys really, at 52 Launch have that DFN, design for manufacturing, expertise, because that is so important. And there's just it's kind of like the patent process. There's so much knowledge that a skilled, experienced person will have about temperatures and profiles and timing and recipes and the shape of something, what's going to fit, what's not going to fit, what's going to cause abrasions and all this, that and what's actually, where you can actually, what's going to work in the machine, what you can actually buy, from a supply
Oh yeah.
chain point of view. It's complex, just like patents are. I had no idea how complex it was, even as an electrical engineer, and until my first product, and I took it over to the manufacturing, spent some time over there, and I learned I didn't know much. So, and that was the same thing with patents. When I, graduated from law school, I thought I, studied all this stuff about patents. I had a lot to learn before I could, really learn to do, write patents or litigate patents or do due diligence and do patent license agreements. All that there's a lot to learn, and I didn't even know what questions I didn't know to ask. So
Yeah, absolutely. And that's one of the reasons we've got sort of so many teams here at 52 Launch where we don't have somebody that's trying to do the product design and then move on to the branding and then the marketing
it's
and
too
then the
much.
sourcing and the production. We've got
Mhm.
a different team for each of those things. And so people can be really specialized and gain
It's
a whole
awesome.
lot of expertise to be able to help clients move efficiently through that process, which often can take many years. We have clients come and consult with us who I ask, "How long have you been thinking about this?" And it's crazy how often I hear 10 years, 12 years, 15 years.
Yeah.
It's like it's dang hard to bring a product to market on your own. Um, there's so many moving pieces. And speaking
Mhm.
of going to market, there's if you've patented your product, there's two
Mhm.
primary paths that you can pursue.
Mhm.
Either you can go into manufacturing yourself and try and
Mhm.
sell the thing on Amazon, on your own storefront, wherever you can,
Mhm.
or you can license your idea.
Mhm.
I'd be interested to hear, maybe what percentages of your clients pursue each of those paths. What do you think is the most effective way to do it? Maybe some combination of both makes sense.
Mhm.
But that's something we talk about a lot over here.
Yeah, that's actually step 6 of my 7 steps process is really, but before you start anything with the patent process, very early on, is figuring out what, if anything, how am I going to monetize this? Like, what are my monetization strategies? And a lot of people are unaware of what's on the menu, and or they think it's going to be one thing or the other. And I've taught some very sophisticated business people, who just were blown away by the fact that you can actually, have an all of the above strategy very easily. And probably it's the best to, not probably is the best to start with getting a prototype, and going to a 52 launch, getting a prototype, getting some sales, demonstrating that there's a market demand, and the people, like, if you think of Shark Tank, the people who really get the interest of the sharks are the people who already have sales, and that their sales are, because it shows product market
Exactly.
fit, it shows market demand, it shows that you actually can sell. It's not just a great idea in your head. It's people will take out their wallet, pull out money, and swipe their credit card and give it to you, to get that thing. And if you can get them to that place, now you suddenly, a lot more options and higher value opportunities can open up. So if you're able to if you get a client comes to you, if you can get them to that first level of, they've got 10 customers, 100 customers, 1,000 customers, and 1,000 sales, or whatever makes sense at, 10,000, whatever is appropriate for that type of product, then as a proof of concept, then now you can license it, or you can be acquired, or you can continue. Now you can upscale the manufacturing yourself and really lever that up and really get the cost of goods down, and do mass manufacturing. Um, but as above all of the above strategy is, you can choose from an exclusive license, say, I've done this once in to settle litigation. I came up with the idea. It was pretty creative. Everybody's pretty like, you can do that? Yeah, we can do that. Okay, so this is how the case settled, and everybody went away happy as they could be. Um, is we There was a oxygen, SpO2 sensor, and we said, okay, you take all the rights in the field of medical, like so hospitals, clinics,
Hmm.
doctors, nurses. So you have that field of use. It's like one sentence at the in the license agreement. And we'll So that the inventor retained everything in the field of non-medical, which included, athletes
Right.
and that sort of stuff, because he wanted to license it to Nike. And so these people had a
Oh,
different business model, and he had a different, target business model, and he retained the ability to do it not in medical. He can't touch that, but he can make it out on his own and license it to, other so you can do all three. You could have exclusive licenses over here in different fields of use. You can chop up and carve up your market into different segments and very easily try to maximize or fully optimize. Because if you try to fully optimize it with one with one licensee, you're missing out because they don't care about, these other segments. They're not going to go into those other segments.
right.
So you can say, well, we'll just give you what you care about, and we'll keep the rest. We don't have to sell it all. So it's like real property in a way. Intellectual property is very much has analogy to, you can carve up subdivide your real property into smaller, and expensive things come in small packages, right? So
Yeah. Yeah. That's a cool solution there. And certainly everything you just said is very aligned with how we think about licensing versus selling. Our goal is always to get clients to revenue as quickly as possible. And in our experience, that means going and
Mhm.
printing 1,000, 2,000, 5,000 units off a manufacturing line and going and selling them as quickly as possible before either you go back and place a bigger order, depending on how that first one goes, or you start looking at licensing deals. But no, I've been known to say this to people on calls. Have you ever seen somebody get a deal on Shark Tank with $0 in revenue? Like you can look it up. I think it happened once, but it has happened a few times, but it's rare because no, we get a lot of clients asking us to do kind of a reduced version of our accelerator program where they just want market research and a prototype. There's nothing wrong with market research or a prototype. They're both great steps in the process of getting to a real business, but they pale in comparison to sales numbers. And they don't help you get that much closer to the sales numbers. They help you feel better, build your own confidence in the product, in the market, in the fit, but they're not a substitute for revenue.
Right. Yeah, I mean, we're looking at a licensing potential sale of a patent or sale of a business. I mean, it's a patent is a it should be considered as a business asset. I mean, that's kind of
Oh yeah.
throughout everything we've talked about today. Is It's a business asset. It's an asset on your balance sheet. If you want to look at it, in terms of if you sell your business, it has some intangible. It's an intangible asset. I think when you sell it, you pay capital gains on it, and so,
Huh.
but don't take tax advice about that. But I'm not a tax lawyer. But it's the point is it has value independent of the operations of the business. It has
Right.
so you can sell it, you can license it. It's sort of again, it's like sort of like real estate. You can sell it, you can license, you can rent it, which is what a license is under
Hmm.
certain very very defined conditions.
Yeah, absolutely. No, exit strategies are important. When you go into business, you should probably already be thinking about it.
Mhm.
And certainly some intellectual property can help you get to a more successful exit there. Um, awesome. Well, before we start wrapping things up, you've mentioned this package that you put together. I'm sure people would be curious to know what they can expect if they go take a look at that.
Yeah. So just for this audience, we've got we have a link that it's thompsonpatentlaw.com/52launch, no spaces, thompsonpatentlaw.com/52launch. And there we've got some of these resources. We got some training videos that I've done that are talking about, one's called Patents for Profits, and it goes through how you can monetize patents and how to think about patents as a competitive advantage. And some
Hmm.
trainings in there on protecting your idea, protecting your brand, and monetizing your IP. That's another set of trainings, each with that individual worksheets that you can work on your own business as to kind of help you can add that into your business plan or your planning.
Yeah.
And you mentioned we call it Craig's 100 times ROI
Yep.
calculator, because that's the three numbers that if you just have those three numbers, you can project out and start to get a handle on. Does it make sense?
Thank you to everybody for watching. If you made it this far, stay tuned for future episodes and give us a call if you've got a product idea.